California's new laws mean expungement is possible. Finally.
A criminal record can linger long after you've completed your sentence, silently blocking job opportunities, housing applications, and professional licenses. Many people don't realize that California law offers a powerful legal tool to help you move forward: petitions to dismiss. It isn't just a legal process, it's a chance to reclaim your future and close the door on a painful chapter in your life.
Petitions to dismiss are the California equivalent of what other states call expungements and are governed by Penal Code Section 1203.4, which allows individuals who have successfully completed probation to withdraw a guilty or no contest plea, enter a not guilty plea, and have their case dismissed by the court. While it doesn't erase the conviction entirely, your record still reflects that a conviction occurred. It is updated to show that the case was dismissed. For most employment applications in the private sector, this allows you to legally say you have not been convicted of a crime. Qualifying for expungement depends on several factors. You must have completed your probation or obtained early termination, paid all court-ordered restitution, and not be currently facing or serving a sentence for another offense. Most misdemeanors and many felonies qualify, though there are exceptions. For decades, California's expungement laws were clear and harsh. If you were sentenced to state prison, you were automatically disqualified from post-conviction relief under Penal Code Section 1203.4. The door to cleaning up your record was slammed shut, regardless of how much time had passed or how much rehabilitation had occurred. Fortunately, recent changes to California law have begun to shift that narrative. As of 2021, a series of legislative reforms have opened the door for certain individuals who serve state prison time to now petition for expungement of their criminal convictions. Specifically, individuals convicted of a felony after January 31, 1973, who served time in state prison, may be eligible for relief if they have been out of custody for more than 2 years, are no longer on parole or any form of post-conviction supervision, and are not required to register as sex offenders under Penal Code Section 290. This relief is not automatic. The individual or their attorney must petition the court for dismissal under the expanded provisions of Penal Code Section 1203.42. The same eligibility standard applies to convicted felons who were granted probation but suffered at least one probation violation. If their conviction occurred after January 31, 1973, and they have remained out of custody for over 2 years, are free from post-conviction supervision, and are not required to register under PC Section 290, they may petition the court for expungement. This represents a dramatic change from previous law, which generally disqualified anyone with probation violations from obtaining relief under PC Section 1203.4. Further expansion includes individuals who were convicted of serious or violent felonies, receive probation without any revocation or violations, and meet the same post-custody criteria. These individuals, provided they were convicted after January 31, 1973, are now allowed to petition for expungement as long as they do not have a sex offense requiring registration. This change is particularly important for people who took probation deals on strike offenses and have since remained law-abiding but previously had no viable relief. Even more revolutionary is the creation of an automatic expungement process beginning in 2023. Under this provision, individuals convicted of felonies after January 1, 2005, who were granted probation without any violations and whose offenses were not classified as serious or violent felonies, will have their convictions automatically dismissed, so long as they do not have to register under PC Section 290 and they remain conviction-free for 4 consecutive years. No petition is required under this provision. The dismissal is automatic, although it may still take time for records to reflect the change with all background check databases. One of the most impactful reforms relates to individuals who participated in fire camps while serving time in state prison. Under AB 2147, a person who completed fire camp and was convicted of a non-violent, non-serious felony may now seek immediate expungement relief with no waiting period as long as they've completed their sentence. This carve-out was designed to reward rehabilitation and support formerly incarcerated individuals in pursuing careers in firefighting and emergency response, areas where a criminal record would otherwise be a major barrier. Ultimately, these changes represent a significant and long overdue shift in California's criminal justice landscape. The expansion of expungement eligibility acknowledges that rehabilitation is possible and that people deserve the opportunity to move forward with their lives without being forever haunted by a conviction from years past. The benefits of expungement are far-reaching. It can improve your ability to secure employment, as private employers are not permitted to discriminate against you for an expunged conviction. It can open doors to professional licenses and reduce the likelihood of being denied housing. There's also a deep personal value. Having your conviction dismissed in the eyes of the court can help you find closure and move on. In legal settings, expunged convictions typically cannot be used against you if you testify in court, unless you're facing new criminal charges. Expungement eligibility and process vary based on the type of conviction. For misdemeanors, the process tends to be more straightforward. For felonies, a common strategy involves first requesting a felony reduction under Penal Code Section 17. B, if it's a qualifying offense, followed by expungement. This combination offers greater benefits, including fewer long-term restrictions. Under Proposition 47, certain theft and drug-related felonies may be reclassified as misdemeanors. Marijuana offenses are now subject to special provisions that allow for automatic dismissal or reduction in many cases. Even infractions may be eligible through a simplified process. Because each case is unique, having a legal advocate to help navigate these distinctions can be essential. The process begins with a careful review of your record. Each eligible conviction must be addressed individually. After identifying what qualifies, petitions are prepared and filed with the court along with any supporting documentation. A hearing is then scheduled and the district attorney is notified. The prosecutor may object, support the petition, or take no position. During the hearing, the judge evaluates your post-conviction conduct, overall record, and any arguments raised by either side. If the petition is granted, your conviction is officially dismissed, and your record updated accordingly. Still, expungement is not a perfect solution. It does not remove your conviction from all law enforcement databases. You must still disclose the conviction in certain situations, such as when applying for public employment, state licenses, or public office. It does not restore firearm rights, eliminate the conviction's potential as a future sentencing enhancement, or remove sex offender registration obligations. For those facing these limitations, other remedies like a certificate of rehabilitation or a governor's pardon may offer more complete relief. While it's legally possible to file for expungement without an attorney, working with an experienced professional can significantly improve your chances of success. An attorney can assess the potential remedies, ensure forms are properly prepared and filed, and help you qualify sooner by seeking early termination of probation. They can also craft compelling arguments to present at the hearing, especially in more complex or borderline cases. For individuals seeking full restoration of rights or to clean up multiple convictions, professional guidance is often the key to a smooth and effective process. A criminal conviction does not have to define who you are today. With the right approach, you can take meaningful steps toward a fresh start. Expungement is not just about paperwork, it's about giving yourself the opportunity to live free from the constant weight of your past. If you're ready to take control of your future, the time to act is now. There is a legal path forward, and you don't have to walk it alone. If you or someone you care about served time in state prison and thought that expungement was off the table, it may be time to reconsider. You could be eligible for relief under California's updated laws. We can help you understand your rights, petition the court, and take back control of your future. Reach out today to find out if your case qualifies.
Don't forget to like and share this video, and for more legal insights, keep watching and subscribe to our channel.